So tonight we're chatting about our last topic of this class, which is on statutory interpretation. Appropriate, as you can probably imagine, to follow last week's section on legislative drafting. Obviously, statutory interpretation is how those bills that have become laws, i.e., statutes, are interpreted. You really have two bodies that can engage in interpretation. The one we most often associate, of course, is the judicial branch of government. But also, we have some statutory interpretation that's done in the executive branch, which is by those state agencies and departments. You may recall from our discussion of the rulemaking process that the definition of a regulation under California's APA Administrative Procedure Act and the Government Code is to implement, interpret, or make specific. The federal APA likewise defines a regulation, the first two, implement, interpret, they use something else where we say make specific. But in both the federal and state APAs, that second purpose of a regulation in its definition is interpret. So despite the fact that the courts of this state and the federal government uh, have laid claim, of course, to their primary role, which is to interpret the laws, we actually do have some statutory interpretation or construction taking place in the executive branch of state government by those agencies and departments and boards and commissions and bureaus in California state government. As a general matter, statutory interpretation, statutory construction essentially mean the same thing. Again, basically, both terms referring to how the judicial branch, i.e., the courts of California, how they interpret statutes. They also interpret constitutional provisions. The courts also interpret regulatory language, regulations out of the executive branch, and they even, since we have direct democracy, one of about half the states, the judiciary also interprets ballot measures using very much the same canons. Also, when they try to ascertain intent with statutes, of course, the intent of the legislature, ballot measures, changes brought about by an initiative, they engage in trying to ascertain the intent of the voters, the people. So again, whether laws are enacted by bills becoming statutes through the legislative or initiative process, or of course, again, those initiative measures, the judiciary engages in interpretation. Why is it important, at least in my mind, to have some basic understanding of how the laws are interpreted? Because just because you have gone through the legislative process and in some cases through the rulemaking process, as well as a result of the enactment of one or more statutes, you also have to, in order to understand government and how the laws are administered, is how also they are, of course, interpreted by the judicial branch, who are the ultimate arbiter of what statutory text, constitutional, regulatory text means. And so, in my mind, understanding the role of the courts and how the courts interpret statutes, and again, as well as regulations, constitutional amendments, etc., certainly is critical to anyone who works with one or more of these bodies of law. And as we know in our brief study back in course one on the role of the judicial branch, obviously from time to time some costly and time-consuming litigation often occurs when there are disputes about ambiguous language in the laws. Now, we, of course, with our bill drafters in the Office of Legislative Counsel who do a wonderful job. They cannot draft a perfect statute at all times to cover every conceivable, fact pattern. And of course, their focus is on what I've always referred to in legislative drafting as the three C's, being concise, clear, and consistent in their language. You know, it's very rare that a statute covers every conceivable scenario or is perfectly clear in every single instance. So again, that's the purpose of statutory interpretation or construction. Now, the courts at both the federal and state levels, and we're going to talk a little bit about, you know, the different theories, including textualists and intentionalists and others. But generally, and most importantly at the state level here in California, the courts begin with the plain meaning or the ordinary meaning of law. In other words, the courts first look at the statutory regulatory language and they say, if it's clear, we're going to apply the plain meaning or the ordinary meaning of those words on the page. We don't have to interpret them or use canons of construction in order to figure out what was meant or what was intended by the drafter. We're just going to follow the clear and concise, plain meaning of those words. In fact, California courts don't look at extrinsic aids or use extrinsic aids, meaning intrinsic analysis is just looking at the language itself, sort of what a textualist does, someone who believes that we just follow the text of the statute and apply it. Um, Again, not clear in all instances, but that's generally their view. California courts say we only look at outside sources or use extrinsic aids if there's ambiguity. And the way the California courts have generally defined ambiguity is when the words on the page, the statutory language, is subject to more than one reasonable interpretation. Then the judiciary is going to say, okay, the plain or ordinary meaning is not clear. There is ambiguity. There's reasonable differences of interpretation of this language. So now we're going to start our role of interpreting, or how do we construct that statute and often ascertain what was the intent of the legislature. So again, extrinsic aids or materials used during the legislative or regulatory consideration of the law's development. So changes in the language of the bill from when it was introduced through several amendments in its final form. That's the intrinsic view, the changing language. The extrinsic is things like committee or floor analyses. Sometimes they may resort to hearing what a legislator had to say in their written word, or other documents that might have been considered in the legislative process in order to shine some light on how do we give effect to this language. These types of aids, including canons of statutory interpretation, sometimes called principles, but more often referred to as canons, again, are trying to get to how should the words on the page be read since they are ambiguous to reasonable interpretation. They're open to reasonable interpretation, differences of opinion. So what was the intent of the legislature, the regulatory entity, or again with ballot measures, the people, what did they intend? As I mentioned earlier, there are some, different schools of thought in terms of how do we interpret statutes. For example, some judges view themselves as textualists, probably the most famous of which is now deceased U.S. Supreme Court Justice Anton Scalia. They focus on the words in the text of the language, and they rarely deviate from the words. There are also some who are intentionalists. They are trying to focus to interpret what is the intent of the legislature. There are also purposivists, and they try to interpret the laws based upon what is the general purpose of the language. What harm or what problem was the legislature intending? What was their purpose? What were they trying to address in crafting that language? When interpreting statutes, the judicial branch generally uses these canons of interpretation of or construction primarily. One case book that I have in my library has over 200 canons. In fact, some legal observers have said for every canon, there's a counter canon. So we can all perhaps have our opinion about the value of the cannons, and perhaps they are used more in an effort to perhaps explain or justify the decision that a judge or justices are making in a case, as opposed to actually leading them to a specific answer. Because again, in some instances, there are canons setting forth the exact opposite of a different canon. We generally characterize these canons in two buckets. One is called a semantic canon, uh, I think more often referred to as a linguistic, the language, a linguistic canon. And then others are so-called substantive canons. And the semantic or again linguistic canons are basically presumptions concerning ordinary language usage, such as rules of grammar. And then substantive canons we describe as being presumptions that are for or against certain outcomes, such as constitutional avoidance and some others that we'll get into. So again, in most instances, judges are relying upon the text of the statute or of the regulation itself, um, rather than immediately going to some of these canons. For example, they might look at dictionaries. Of course, which dictionary should you use? And do you use a dictionary today at the time of the uh, litigation, the controversy? Or do you utilize the dictionary that was in existence at the time a statute was enacted, for example? In general, I think the courts, particularly of our state, generally ascribe the legislature as using specific words for meaning and that they act intentionally. They like to say the courts do. They act intentionally in choosing the language that they place into statute. So, for example, the courts in our state generally try to avoid the notion of reading something into the statute or reading extra language that doesn't actually, that's not actually on that page. Also, the courts in this state, just to emphasize this point, ordinary or plain meaning comes first. Only if there's an ambiguity do we try to ascertain the intent or look to some of the canons to try to, get us to the right place. In some other states, their courts will, whether there's ambiguity or not, they may properly review extrinsic aids. But again, in California, it's a two-step process. If the plain or ordinary meaning is clear, then that's all we rely on. Only if we have ambiguity do we then turn to those extrinsic aids to try to help us. The benefit of these canons, of course, and knowing about the canons, is that the legislature, the courts, executive branch agencies, the regulated community should all have some predictability when statutes are being interpreted. And so, again, what are these things that we're ultimately looking into? Whether you're a lawyer or a non-lawyer, again, statutory construction is important and it's helpful to understand whether you're drafting legislative or regulatory language or you're trying to interpret it. We have to have some fundamental understanding how the courts in this state and even at the federal government are going to look at statutory or regulatory language and what rules generally try to guide them. And so, as I've mentioned before, they don't have to follow these rules in every instance. Again, I would suggest that they are on occasion used to assist the judiciary to justify the position that they're going to particular take in a dispute in resolving litigation. Um, but I think also that there's always some tension here because I think the general rule is to effectuate the intent of the legislature. So yes, it makes sense in that regard to try and give full effect to the language of the statute or the regulation, and of course rely upon the language that you see on the page. But as I said at the outset, it's not, no statute nor regulation can be perfectly crafted without the slightest bit of ambiguity. And also, even when you think that everyone understands what those words mean, they may or may not. I got very early on in my lobbying career a good taste of this. I had worked with law enforcement officials, district attorneys, sheriff's association, and police chiefs to draft language in the California Penal Code. And we agreed upon language, and the four of us, the four groups, thought that the language was clear, no problem, case solved. There's the language. A couple years later, I got a call and was surprised, to say the least, to find out that law enforcement on the street, this is not a criticism of them, but that sheriffs and police officers on the street were not interpreting that penal code provision in the way that we had drafted it, and that those four groups who drafted it thought was perfectly clear. In other words, we thought that the plain, ordinary language was right there on the page in the penal code. How could there be ambiguity? How could anyone read it differently? And yet, that is what was occurring with law enforcement officials on the street, right? They were the ones who were taking the language of the statute and applying it in real life. And in real life, in many instances, they were arresting people for violating this particular law, even though those groups had tried to create clear and concise language why people wouldn't be violating the statute. And yet, law enforcement on the street, the people who are actually applying or implementing that statute, were not reading it that way. Sure enough, we had to go back, of course, the following year once it came to light and make some clarifications to that language so that there wasn't that ambiguity anymore. But again, here you had folks in Sacramento at the state capitol working together, seasoned lobbyists who had spent time with penal code provisions before. They had worked diligently with input from all of these groups, and we all thought the language was clear on its face. And again, in this example, that was not the case. So probably in my third year as a lobbyist, perhaps, I got a real awakening that despite what we might think up in Sacramento in crafting statutory language, when called upon to implement or interpret it by those people who are charged with doing so, the language may not be as clear as we thought. And so There are some instances where ambiguity does in fact come about. I think there's a wonderful case. I don't like the outcome of it, but still, I think that there's a wonderful U.S. Supreme Court case with the word at issue was use or use, and it was basically the use of a firearm. And so, I think the statute did not define the word use or use. And I think the average person doesn't need some legal explanation of what use is, you know. And yet the whole case and the criminal prosecution rested on this one word, use of a firearm. And the defendant basically argued use of a firearm means that, I have it in hand and like give me the drugs or I'll use the gun. The prosecution said, no, no, that's too narrow. The fact that you traded the firearm for drugs meant that you used the firearm in the commission of that criminal offense, purchasing illegal drugs. And so it went up to the U.S. Supreme Court. The majority said, no, trading the gun for the drugs was using a firearm in the commission of that crime. The minority said, are you kidding me? Use means, again, what I think the average person would think use meant, in the commission of the crime. But here's an instance where a criminal case and prosecution was successful, and it went up to the U.S. Supreme Court. So the whole case revolved around how does somebody define the word use, which again, I think in most instances, we would not provide a separate definition for what use means. But perhaps going forward, we'll actually have to define words like the word use or use, at least in the criminal code context, right? Anyways, just some real life examples of these types of things where, again, you might think to yourself, use or use is pretty straightforward. What's the problem here? As you may recall, when we talked about the structure of government, again, in the hierarchy of laws, remember Constitution at the top, just like at the federal level, statutes next, regulations, and then common law or judge-made law. So our statutes are all in those 29 codes, right? Starting with business and professions, ending with welfare and institutions. Believe it or not, those 29 codes have some general provisions, some preliminary provisions they call them sometimes even definitions. And we've also codified some statutory interpretation guidelines. So what are some of those principles? We've said that when we give titles to articles or chapters or code sections, that shouldn't affect the scope, meaning, or intent of those provisions. The present tense includes the past and future tenses. We've got other provisions that say the masculine gender includes the feminine and the neuter. We have moved over, we the state of California, we in 2017 or so, I think, the legislature adopted a joint resolution or a concurrent resolution, technically, between the two bodies, jointly done by the two houses, the Senate and Assembly, to require the use of gender neutral drafting. So that's what you see today. Of course, we have over 155,000 statutes. They don't go in and change all of them at once. But today, instead of saying policeman, we will say police officer, for example. It's interesting because we used to do just the masculine, and then we went to he or she, him or her, And now we've gone over to gender neutral. So if you look at California statutes, you can find all of them. Again, masculine only, um, masculine and feminine, and then again, so-called gender neutral drafting is what we try to do today. How do the codes get updated? We don't do it in one fell swoop. What generally happens is that when a bill proposes to amend a code section that's existing today that has like policeman, they will ledge counsel, not at the request of the author or something, just because of that rule, they'll go in and change it to police officer. And so they'll update the codes slowly but surely. All new statutes, of course, are going to be drafted in a gender neutral manner. Two other important provisions that are in all of the general or preliminary provisions of the California codes is mandatory and permissive words. And we use one for each in California statute. And that is the word shall is mandatory and the word may is permissive. There's no other way. In a number of states, they use the word must to be mandatory. But in California, we only say shall for mandatory and may permissive. So, what are some basic guidelines? What's the purpose? So, again, generally, statutory interpretation or construction is to interpret statutes and regulations by the courts. And, again, we're starting with that plain language. Then we are resorting to other extrinsic aids to understand what was intended if there's, ambiguity. I think an important one in light of we're trying to effectuate the intent of the legislature, again, at least in my book, um, I think that the most important aid is both the legislative history and then forms of intent. So again, history is what happened to the bill, you know. Did it change language? Was it amended through the process? And then other legislative aids go more towards demonstrating intent. Does the law or the bill itself provide codified or uncodified legislative findings and declarations? Does codified or uncodified language from that bill include statements of legislative intent? What about, again, committee analyses, floor analyses, statements by the author? In some instances, the courts have relied on things generated out of the executive branch, like the enrolled bill report for the governor when he or she considers a bill that's on their desk, or reports from the state bar, the California Law Revision Commission, and things like that. Um, we've also created a number of general canons that we find in California law, general versus specific. The general presumption is a specific statute is in conflict with a general will prevail when it's on the same subject matter. So, in other words, the more specific should prevail upon the general one. There's also the more recently enacted bill or law. In other words, if you've got two laws that are arguably in conflict, the courts generally apply the more recently enacted statute is given more weight than that earlier enacted one. So the more recent statute takes precedence, if you will. We've got some other interesting ones. Um, the last antecedent rule. So qualifying words, are applied to any word or phrase immediately preceding that word, for example. If we have some general words following particular items, like a list of things, like different types of paper. The general words are generally presumed to only apply to those items of a same general nature or class. Um, when we list specific items, the courts generally interpret that to mean that excludes all other items. It's why, for example, in a definition, if we say the word X means versus the word X includes, right? Means is very specific. Includes could be what comes next, but it may also include other items. So, for example, when you're defining a word or a phrase in statute, this is why you want to be careful. Am I saying the word or phrase means something specific, or am I giving examples? Includes. Sometimes you'll find in California statute the phrase includes, including, but not limited to, very clearly saying, hey, this is just a sampling, but the definition could include more things. And that, of course, could lead to ambiguity or litigation, right? Okay, this particular item isn't in there, but it says including but not limited to. So shouldn't my item apply? Well, then you get into, is it of a similar nature as to the items, right? Is it in the same class of items or categories, things like that? Another issue that often occurs in interpreting statutes in the state is prospective versus retroactive. The general presumption, as you would probably expect, is that new statutes apply prospectively. To apply something retroactively, the courts in California have generally stated that they are looking for evidence that the legislature intended the statute to be applied retroactively. And that's not really extrinsic language, that's intrinsic language. In other words, you want to make it clear in the statute itself. This is intended to apply, or this applies to cases or disputes arising on or after a retroactive or a prospective date. Now, of course, retroactivity can raise other concerns, like are you violating, are you trying to undo an existing, you can't interfere with existing contracts, for example. So there might be other issues that are raised, again, which is why California statutes and most other jurisdictions are presumed to apply prospectively. Um, there's also a whole area of law, both at the state and federal levels, and this was recently overturned last year, what's called Chevron deference at the federal level. Basically, the that was from a U.S. Supreme Court case involving Chevron, yes, the oil company, as to basically how much deference or weight should courts at the federal level give to a ruling or an interpretation, say by regulation, of an executive branch administrative agency. Historically, before they overruled, the current court overruled the Chevron case, courts generally give a fair amount of deference to the interpretation of a statute by an executive branch agency or department. Why? Two reasons. One is we generally believe and expect, and that's a fair one, that they have particular expertise, right? In other words, the folks at Cal EPA or the California Department of Insurance, etc., they have expertise in those areas of law. And of course, they are ultimately charged with interpreting, like by way of a regulation, and enforcing a statute. So that's why historically they are given a fair amount of deference. The federal courts have begun trying, for many years actually, have been trying to narrow the Chevron deference before getting rid of it entirely last year, going after the so-called administrative state. But that also is a canon of statutory construction, again, where we're going to give some degree of deference to that agency and how they interpreted the meaning of that statute. We also have a number of construction rules in statute, generally found in the California government code. So, for example, we have that notion of a later enacted statute basically takes precedent over the earlier one. We have a general presumption about that. Um, we also say, for example, that statutes may be repealed, except when we're dealing with vested rights. So again, we can't impair vested rights. We can't impair existing contracts, for example, right? Those things we've actually codified in California law and in the government code. I want to turn to legislative intent and the California courts. Again, for somebody who has spent his career in the legislative branch of government and has, spent lots of time with drafting, negotiating, lobbying for and against specific statutory language, I think on the natural, someone like myself wants to give or have the courts give full credence to those words in the statute, and where there's ambiguity to try to ascertain the intent of the legislature. But to be fair, California courts have historically taken, I would say, more of a limited view of legislative materials in trying to determine intent. They would prefer to utilize their canons of statutory construction rather than rely on legislative history or materials. And in fact, California courts have generally relied upon only certain specified types of legislative related documents in order to try and gain an understanding of the meaning of a statute or to try to ascribe some intent of the legislature. Again, I think determining legislative intent is very important because while there might be ambiguity in the law, very legitimate legal disputes as to what two parties may believe certain statutory or regulatory language means, um, we really have to try and figure out, and ultimately this burden falls on the judicial branch. We're trying to help them figure out what's the right interpretation of the particular statute. There's a lot of concern by the state courts and even the federal ones, but California courts in particular, regarding the bill authors, the author of the law, of the bill that created the statute, and what their perspective is. Because they try to ascribe legislative intent to the entire body, all 120 members, the 80 assembly members, and the 40 senators, right? That's what they are ascribing legislative intent. So they like to say the documents, like a floor analysis of a bill, that is a proper one to use because we can assume, it may not be correct, of course, but their assumption is that all legislators have read that floor analysis and agree with it, and therefore that would describe a realistic view of what the legislative intent was in enacting the bill. Now we know realistically that not always are those analyses or bill language actually reviewed by all 120 legislators, but nonetheless, that is something that the courts of this state and even the federal government generally does. Now, I raise this issue in particular in trying to ascertain legislative intent, not as a criticism of the legislature, for example, or something like that. I think when, especially like at the end of session, when they are casting perhaps hundreds of votes on a single day, that they may not have read every bill and all the legislative materials, committee and floor analyses, and then everybody generally be in favor of the voting in favor of the bill, all share the same collective intent. But again, that's what the courts of this state try to ascribe. Um, I also think that California's legislative um, materials are limited, particularly in comparison to those used at the federal government with the U.S. Congress, particularly um, the Senate and Assembly daily journals, which are nominal um, compilations of legislative activity, as opposed to, say, the congressional record, which contains a verbatim, it's a verbatim of all the committee statements, the floor statements, etc. So it's a verbatim record of what has actually transpired. Again, not a criticism of the California legislature or the legislative process. I think just an acknowledgement that, in fact, there is limited material produced by the legislature beyond the analyses in committee and on the floor, and even some of them are limited. In Congress, they use markup sessions in their committees. So they, on one day, will take testimony, pro and con, for and against a bill, and then they'll spend another day or multiple days in markup sessions because they're actually reviewing the legislative language in a federal bill, discussing and debating it, working their way through it. They call it a markup session because they are marking up the contents of the legislation by way of potential amendments, discussing and debating why are we choosing this word or this phrase here versus something else. That can obviously give the courts some very keen insight, right? Oh, well, this litigant is trying to read into this statutory language in such a manner, but look, based upon that House or Senate committee markup session, they actually considered how that litigant is arguing, and they rejected it and went with instead the language you find in that federal statute. Obviously, that is not necessarily binding on the court, but I would say is a pretty strong indicator of what the federal Congress, for example, was intending or trying. So there's a lot of benefit from not just the verbatim transcripts from the congressional record of debate and discussion, but also those committee markup sessions are very helpful. Whereas, again, the Assembly Daily Journal, the Senate Daily Journal don't have near that kind of detail, and therefore the main source of intent in the legislature is a committee or floor analysis. That's also why I'm of the opinion that the statements from a bill's author should be given much more credit or deference than California state courts ascribe to them. If you've looked at committee or floor analyses, there's not a lot of detail as to the specifics of language. They generally are a statement of what is existing law in this area. What does this specific bill propose to add, amend, or repeal in the law? What are the arguments generally the author and proponents? What are the arguments generally of the opponents? And then some committees, not all, might raise questions, policy questions, suggest alternatives, maybe even sometimes alternative language, but at least alternatives or proposed amendments, right? But rarely do they discuss like specific language and the reasons for it. Like, why did we use taxpayer in this tax law and we used person in this one? There's rarely in those analyses, oh, we considered using taxpayer, but we decided to use this broader person in this particular tax law for X, Y, and Z. And therefore, the courts are going to say, well, why did they use taxpayer here and person here? We don't have any explanation. So the judiciary, in effect, has to make a judgment call because they can't find a specific statement in those analyses, for example, or there's no verbatim transcript of the committee hearing where they discussed why are we using taxpayer versus person. And so the courts in this state are left with trying to come up with their own reason or reasons for why those two different terms uh, were used. So again, California courts rely on only certain types of legislative materials. But in my book, I think they take an unnecessarily narrow view of which items are appropriate to use to ascertain or to effectuate the intent of the legislature. I've often advocated, quite frankly, that the judiciary should spend some time understanding the legislative process, and the legislator should spend some time understanding the judicial or statutory interpretation process as well. Um, Want to touch upon a few other um, items in here. We have a couple of canons that are common, just to run over. Some are clear statement rules, and these are based upon some quasi-constitutional provisions. We have what we call tiebreaker canons when the interpretation is kind of a 50-50 split, can go either way. We have some interesting ones. One of my favorite ones is called the rule of lenity, Lenity. It says that penal codes or criminal law statutes, where obviously the intent is to punish an offender, that the courts must construe those types of statutes strictly or narrowly. In other words, if there's unclear or ambiguous language, we want the courts to read it in light that is most favorable to the defendant, not the prosecution or the people. A popular one or a common one is constitutional avoidance doctrine, sometimes canon doctrine. Basically, that says that statutes are to be construed whenever possible to avoid questioning their constitutionality. Sometimes it's called just the avoidance canon. But again, it's the courts will be loath. They try not to interpret a constitutional issue unless they're really required to do so because of the dispute. So they try to avoid it. I mentioned earlier, without using the canon's name, but the rule of the last antecedent. It says that qualifying words we apply to the words or phrases immediately preceding that qualifying word. The serial comma rule. Yeah, that is a grammar canon, but it is a canon or a rule. Basically, if you've got three or more items, we set each one off by a comma. Why? So that they are viewed as independent of one another. In other words, if I say, I like chocolate ice cream, vanilla ice cream, and raspberry, if I don't have a comma between the second and third, are they three independent ones, or the last two a combination? If we use the serial comma, a comma after each one, then we know that they are independent of one another. An important one is the whole act rule. This is one of those textual canons, and it basically instructs the judiciary. We don't read the one code section or the one word or the one phrase in a statute all by its narrow self. The whole act, meaning we're looking at the whole statute to try to ascertain what did they mean in this specific context or in this one statute. How does that statute and our proposed, our the court's reading of it or proposed interpretation, how does that comport with the rest of the statutory scheme? We also have the rule or canon against surplusage. This goes back to, I think, the textualists. In other words, we're not going to read language that would render words on the page, words of the statute or regulation, as surplus language. In other words, we ascribe meaning to each and every word of that statute or regulation. Why it's also important, coming full circle to the drafter, draft with a purpose and make sure that every word of the statute plays a role in it, because the courts generally will read every word and not say, they couldn't have meant to include that, or that word's unnecessary, we're going to ignore it. No, because the legislature drafts with a purpose, right? We've got a couple of our guest lecturer mentioned a couple of the Latin phrases of those canons, and just to run through the four again, only because they come up a lot, and you'll see them in writings about statutory interpretation. Adjustum generis. It says when there are general words in a statute followed by specific words, then the general words are read to be the same things or of the same kind as the specific ones. Expressio unius, when a statute includes specific items, that list we presume to be exclusive. And if you're not on the list, we don't read anything else into that list. In pari materia, this is one that we sort of mentioned in terms of like the whole act rule. It's analogous to it. It says that when you're dealing with statutes on the same subject matter, we construe them all together. In other words, if you find ambiguity, the courts use this impari materia canon to say, I'm going to look at the rest of the statute or the surrounding statutory scheme in order to try and determine or ascribe a meaning to the ambiguous provision or provisions. The last one of the Latin-based ones is nocitor, and it says that we interpret an ambiguous word or phrase taking into account that word or phrase's use in the text itself, that we find it in the statutory or regulatory text. Now, I mentioned earlier that the California courts have what they call cognizable versus non-cognizable legislative history. In other words, there was a decision at least 15 or more years ago out of the Third District Court of Appeal, which is based here in Sacramento. It's the Kaufman and Broad Communities versus Performance Casting or something. Forget the full name of it. But it basically went through the court decision. You can see it with citations of legislative history that can be recognized and used by the courts. Now, the Third District Court of Appeal represents a geographic area, and it's not binding on the other. There are a total of six districts in the state of California with a court of appeal in each one. And then, of course, we have the Supreme Court. but the Supreme Court has followed Kaufman and Broad and other districts around the state. So it's in a way sort of the law of the land. And it actually goes through, again, committee analyses and author statements and things produced by the executive branch and law revision commission reports and all these types of things that litigants over the years have tried to say this is a showing or proof of what the legislature intended. So the three justices on the Third District Court of Appeal in the Kaufman and Broad case said, all right, we're going to go through all those things and we're going to say in our court, and again, most other courts follow Kaufman and Broad, but at the time they said in our courts under the Third District, we will only recognize or take judicial notice, it's properly called, of these specified items. And the items that we declare to be non-cognizable, we will not give judicial notice to or accept them as kind of proper legislative intent or legislative history matters. So I think as I close out the hour here, I think again, those are the main things to be aware of, at least from my perspective. I thought Jessica's presentation to us last week was obviously outstanding, and I think she got into a lot more of sort of the schools or theories of interpretation, some of the major proponents of those different theories, and touched upon a number of the canons, trying to fill in a few of those items and again add, I guess, sort of my personal perspective on some of these, particularly like the use of legislative history and intent materials in order to give a proper interpretation to a statute here in California. So with that, I'm happy to field some questions if folks have them. Otherwise, give you the rest of your evening. All right. Well, thank you. Feel free to reach out if you have any questions or want to discuss, statutory interpretation or other things that we've covered in this current course on the legislature and process and bill drafting, and again, how the courts of this state try to construe statutes and regulations. Thanks and have a great rest of your evening.